to authenticate, and then attempts to authenticate using a table that they constructed for authentication purposes. That's not how you do a desktop application. Not the way you're supposed to do it. You're supposed to do it by creating users in a database, granting them group permissions, and then putting group permissions on every object. And then when the database is connected to from a desktop application, it usually connects using that person's credentials. And then if you've got a proper database like Oracle, DB2, PostgreSQL, you're going to have a rock solid permission structure where it's going to check every object, and you're not going to have the ability to get an answer from any object if you don't have permission. It doesn't work that way. That's the whole point of the structure. Structure where it's going to check every object, and you're not going to have the ability to get an answer from any object if you don't have permission. It doesn't work that way. That's the whole point of the structure. Well, and I can understand that, but a lot of using desktop applications could very well be architected correctly. Well, and I can understand that, but a lot of using desktop applications. Oh, okay. I just hadn't heard it pronounced like that. I read a lot. I know what you're talking about. Sorry, I just hadn't heard it pronounced. Yeah. No, that's perfect. That's perfect. No, you're right. I was wrong. I missed it. I read a lot. I know what you're talking about. We're being recorded and broadcast, probably.
So anyway,
You're right.
so anyway, they set the web front end onto an actual application by using an API layer. So what happens is on something like that, you could actually go in and do things.
We're being recorded.
Essentially, we're supposed to be doing.
Right, but that's because what they did was when they started that application up, that little API application, they connected using some kind of an administrative right.
No, the user's own login.
But in order to do that, it would have to make a new connection for each request. And almost no applications work that way.
Yeah, it would make a request each time. In fact, most of the time when we do, like, for example, we have an API on the
But in order to do that,
the login once, and then we give an expiring token to them.
see, but
And so
we don't use that.
Send the token back with every one of them.
No, don't do that. That's bad. That's really bad. You know where that comes from? That comes from the web. 20, 30 years ago, when only idiots wrote web pages. What you want to do is you want to do something more like envelope, which is you take the credential, you send it to the API. The API encrypts it, gives it back as a cookie. The cookie is set.
We can't do
The cookie has. Oh, you can't do cookies.
Nope.
Well, how are you going to do security?
Oh God, no! You never ever do security with cookies.
Or
no. Testing audio, 1, 2, 3. Testing audio, 1, 2, 3.
Hey, Brian, can you hear me?
Sometimes the audio is bad, so if they're watching,
Well, he's watching now.
give us some feedback.
Great, let's wrap up.
Some good feedback.
So, upon the announcement.
No, go ahead.
So how's the volume, Brian? Can you hear me?
Hey, folks, we're going to start in about 5 minutes.
Is that better? Is it better now? This is about the volume I'll be speaking, probably. Well, maybe a little bit louder. Okay, I'll leave it here. I'm going to turn the mic off to save battery until I get up.
Yeah, that's an interesting dynamic.
These old timers, I think they can get by without. Most people signed it. Oh. I like to get a good count. It's all about the topic, isn't it?
Somebody said there was no sound and all the
You know, is this thing? Well, I better check it then. Testing audio. Testing audio.
Okay, folks, let's get started. So welcome to Plano Software Entrepreneurs Meetup. I'm Tony Klinkert, the founder. We'll have just a few minutes of discussion, and then we'll get to our keynote speaker. This is one of the larger groups that have come out, so I'm very proud about that. It's quite a lot of people, but I think it's all due to Kels and his topic. We normally have about 30, but we had 50 RSVPs, so that's good. We're growing, so that's great. But I'll be giving a little bit of a agenda discussion and then administrative items. Then our Kels will come up, and then we can do some more networking. So, Plano Software Entrepreneurs. So how many folks have been to one of these? Okay, quite a few. And how many are new? What would you say? Is that 50-50? About 50-50. So, for newcomers, thank you very much for coming. And this slide, the old timers, you know, you can just kind of go to sleep for 5 seconds when I go through this, because I go through it every time. But it's for the newcomers, okay? So who are we? Well, we're entrepreneurs or interested in entrepreneurship. We're not afraid of software. We either program or can use it quite well or want to use it. So I thought to found this meetup for folks like me. I'd like to meet like-minded folks. I have a tool that I've developed I'd like to commercialize. But how do I take MATLAB on a workstation and put it on AWS, the cloud, and then e-commerce, you know, all this stuff? As an electrical engineer, I don't know how to do all this stuff, right? So meet some people that can maybe collaborate with and talk to me about how to do my thing, and I can help those of you that are interested in ideas with wherever you are in the journey, which sometimes is just, wow, I want to listen to a speaker that's been done that, or I want to listen to somebody advice, special, trying to create those kinds of sessions. Okay. I don't know if you got the message from me, but about 3 or 4 days ago I said, for those of you that RSVP'd, think about some event or item of interest. I have 10 seconds to brief the crowd on anything in the entrepreneurial ecosystem out here in North Texas that might be of interest to the others. I don't know if anybody got that note. Now's the time. Does anybody know of any out there, just for the benefit of all of us? Go on. Yes. Play. So launch pad. So for those that, we're recording this and we're streaming globally on YouTube with my little rinky-dink experimental setup here. So for those that may not have been able to hear Clay, there's at Launchpad, that's a, what type of outfit? At a co-working space. They're going to have pitch sessions. It's in Frisco, Texas, and it's at the Dr. Pepper Center, and they have a big prize. When? Well, it's a big annual event. These are companies that they've been mentoring throughout the year, and they have Okay, so if you need more information, just Google search the Launchpad. Yes, one?
For those who are interested in blockchain software and technology, on Meetup there's a group I'm running called Blockchain Law for Everyone. It's called as another meetup. Our next meeting is August 15th, 5 p.m. We're currently holding it at Bravo Tech, which is the northwest corner of Fullway and Elliott. And you can go and sign up over some articles and whatever. Some guy was really good enough to giving a presentation on validating web pages and web store documents as well. We don't focus, on the cryptocurrency so much. Obviously, part of it, focus on the underlying technology, how that works.
Okay, so announcement on blockchain law meetup. You can search on that and find out the details. One last one, maybe?
By the way, the guy I don't know if you're getting good.
Okay, we'll let you know. Linux? Linux Academy? Linux Academy. So check that out for more information. Okay, well, thank you very much for that. So we're growing. We're now up to 1450 plus members. Okay, typically, like I said, we have 30 per meetup. Thanks for word of mouth. Get the word out. We try to get good speakers in and trying to grow the meetup in terms of attendance. And how can we make this more valuable for you? Go ahead and, one dream I've always had about meetups or even conventions has been if there were a tool, smartphone app that I could say, here are my interests and here's what I'd like to get out of the meetup. In other words, here's who I'd like to meet or something. And in the back end, it makes connections. And so you go, oh, meet Kels, meet somebody, meet somebody. So that would be my own input to me for a question like that. So if you guys have any creative thoughts or ideas on how to make this more valuable, shoot me a message and we'll see what we can do. I mean, we're software programmers, many of us, so, maybe we can do it. Match.com. I like it. So upcoming sessions, we've locked speak. In September, I don't know, some of you may have remembered James Loomstein from SMU, his pitch on marketing back in the February time. I sent out notes to past speakers and say, hey, we want you back, and he jumped on it. And so he'll be back in September. In October, Rex Curious, he's founder of Panda, he gave a very good one for those of you that were here. He's a CTO founder, and built this company in Frisco to quite a substantial company. So he gave us good tips. He didn't want to be filmed on the YouTube stream because he said, I want to make this, I don't want competitors to hear. So it was a very good session. Anybody remember that one? Rex's session? Yeah, that's a good one. So he'll be back in October. In November, we have Kevin Winters, founder of Company Mileage. That's a very interesting new app, and so he's going to be out here talking to us. And then in December, John Shapiro, director of UTD Venture Development, he's the director of this, and collaboration with other students to speak. So that's a great lineup of speakers. So a lot, just thinking up ideas of how to generate interest. Hold on. this on the agenda, I want to promote something of your interest. I don't want this to be a commercial thing. I don't want this to be, all about that. I want this to be content filled. But hey, there are past speakers, and there might be speakers in the future. Get up and give us a 1 minute commercial. So here's SMU. They couldn't come out, but Jerry White is the founder of Cruise Entrepreneurship Center, and they're having starting a business starting in October, right? So if you want more information, you can go to this, software entrepreneur meetup downloads at tinyurl, and that'll get you a Dropbox where I put in today's presentations and the brochure from SMU. Look at that. Right up, Bob Kerr. He's from Oski Blue. John Ken out a few months ago and gave us a very good talk on online social marketing.
Yeah, so my name is Bob. Briefly, with John, we are now offering IT help desk support, cloud services, and HIPAA compliance. I just want to let you know about that. So perhaps as you're going about your business, if you need some help to keep your machines running and you can worry about your software development or your business, let me know. And as you mentioned, of course, we can certainly help out when it comes time to doing your online marketing. Anyway, nice to meet you.
Any questions?
Yes. Well, we're mostly finding people who have gone through some sort of CompTIA training, so they're already well versed at that. Depending, we'll take on somebody who's got some native skills and sort of groom them for that, but for the most part, it's people who have some CompTIA training. Thank you.
Okay, so as always, if this is your first time, please fill out a form to indicate interest. What we'd like to continue to try to evolve to, which is little groups that build, apps or prototypes. Okay, the one that I founded this meetup on, it was my idea to build a little prototype to put a service on the cloud, called it a generic basic service. I'm still trying to get a little team together to do that. It just seems like everybody has such a diverse set of interests, everybody. It's like, come on, I put it on working, I'll put my secret sauce in it, you put your secret sauce in it. And, we go our separate ways, and we help each other. That's it. I didn't get a lot of interest. So I'm going to, forever hopeful, I'm going to keep trying to see if I can do something like that. But fill out the form to understand your interest, and we'll get a database together to try and see if there's patterns there or something that helps the meetup. I'm going to send this around. Please donate. There's a couple of bucks there, or you could do the donate button on the and put. This room costs a little bit. Meetup, they want a little bit. We have a little tiny token of appreciation for the speaker. Oh, and we have a raffle gift. So if you put your business card in here, at the end of the night, we'll have a little raffle for a little gift. Do take some photos and post them on Meetup. Just shows a lot of activity. Do give us a good review if you like the talk. And subscribe to the YouTube channel, because what will happen is when I start streaming, you'll get a little pop-up that says, hey, Plano Software stream, and then you can, watch it. Plus, if we 100 subscribers, you can get a vanity URL, so that's another one of my, I'd like to get that. And download tonight's presentations here at Plano Software Entrepreneur .com. Finally, do you know someone who has successfully bootstrapped a business? Might they want to speak to our group? we'd like to hear from successful founders, startup folks, CEOs, CTOs in a startup, primarily for lessons learned, mentoring, coaching. Also, anyone from the ecosystem of entrepreneurs here in the North Texas area. For example, professors, SMD, or co-workers type people that would like to foster more activity in the entrepreneurial space. So if you know someone like that, please shoot me a message and maybe we can get them on the agenda. Absolutely. I could get on that list. Yeah, I mean, if they've got a story to tell, have them talk to me, and we'll figure it out. Good job. Good idea. Okay. Any last questions before we get to the main event? So this month's presentation is by Kels Wilson. He is a practicing patent attorney. He does patents, privacy, and data protection law. He actually served 13 years in the U.S. Air Force, where he did things like radar jammers, cryptography, and satellite control. So his house now does work in patent prosecution, licensing, and litigation. He's got a PhD in EE and an MBA and a JD. So he likes to collect credentials. So his talk, you will learn the following bullets, which you all saw on the message. So please welcome Kels.
All right. Okay, the audio is good.
I'll give you a thumbs up or thumbs down.
Oh, wait. Did you have to change your presentation? How many of you guys have seen that movie, Mr. Banks? Did you cry? Be honest. Did you cry? You didn't? How? Well, I went with my kids and I had to hide it. Oh, I just got something in my eye. Well, I think I'm going to make some of you cry tonight. Patenting software, actually trying. All right, there's the word, trying. And anything that involves lawyers, the meter's running. So it's a lot more expensive than it used to be. So, disclaimer, I have to put this up. I'm a lawyer, and if I was talking to a bunch of lawyers, I wouldn't have to put this up. I think they all understand. But unfortunately, I have to make it very clear, I'm not giving you all legal advice, and you are not clients, and nothing you tell me is confidential. That doesn't mean it's not proprietary to your company until you tell it to me, but it's not confidential if you tell me tonight. This is a real problem. I was in a lawsuit a while ago, and this law firm that was helping me, we had spent a lot of money, and they backed out of the lawsuit after I'd invested a whole lot of money and I couldn't recover any of that. Why? Because years prior, somebody from the company that was on the other side of the lawsuit had gone to a conference where some lawyer was speaking and had gone up to him and asked him a couple questions. Nothing important, nothing big, but it was enough for them to have a colorable argument that there was a attorney-client privilege. So right now, we're just making clear that's not going to happen. All right?
Before you start, I would like to
Yeah, he's another lawyer, so yeah. All right. Okay. Reference ahead and watch the URL. You'll understand. Okay. So who am I? I know Jerry doesn't like this, but here it is. I have been a patent attorney since 2005. I'm second career attorney. Um, I was originally a engineer in the Air Force. I got a PhD in electrical engineering, computational electromagnetics, electromagnetic field theory. So it was a lot of like stealth aircraft design, radar jammers. That's what I was working in. For programming, since this is a software, I gotta tell you, I was doing assembly back in 1979. I know some of you think, well, maybe I don't look old enough, but I was. I programmed Z80s with hex keypads that had single line LED displays, right? No joke. They used to have those things back then. Okay, and I wasn't making cave paintings too. Later on, I moved to BASIC. I actually learned assembly before BASIC, and then I was doing Fortran when I was in college. Any of you program in Fortran? Really? Some of you don't look old enough. All right. Okay, and then I've patented software programs, not only for myself, but also for other people. And I've watched patent rules change from the front row seat. You know, from trying to get patents early on software, and then the laws changed, court decisions came out, and then we started getting other types of rejections. And I could see, oh, these rejections are new because of this case or this change of the law. I also have done patent litigation. So prosecution, if you go see the attorney and you try to get a patent, right, to one to begin with, that's prosecution. Then if you try to get money from somebody else, that's licensing. But if somebody's infringing or your company is accused of infringement, then you hire a patent litigator. So I've done all three of those activities in relation to patents. Most recently, I've been doing litigation, and I know firsthand how easily a lot of software patents can be invalidated. It's one thing to get it issued, okay? It's another thing entirely to keep it alive through a lawsuit. That is really difficult sometimes. The reason is because you go sue somebody with a patent, and the other side's going to dig up a PhD that's been working in the field since before you were born, and they're going to find something that the PTO had never seen. Anyway, my first experience as an inventor was in the early 1990s, and I had a really bad experience. And today, if somebody had done what happened to me, they'd be disbarred and not allowed to practice patent law anymore. That experience was awful for me. And so I kept having ideas, and I said, well, I'm going to become a patent attorney, become my own patent attorney, and I won't rip myself off. And I haven't yet.
What happened to you? Do you mind explaining?
It's kind of a long explanation. There was a gap in the ethical rules. And there's a cottage industry sprung up to exploit it. And apparently enough other people got burned by it that the rules changed to fix it. But it's explaining the gap is a bit complex. I'll explain after if you want. All right, so hopefully I can save you some time and frustration and adjust your expectations now before the meter starts running when you go talk to an attorney, and you be a little bit smarter about it. You know, maybe you do need to go see an attorney, okay? Well, that's fine. You go do it, but you have reasonable expectations about how much it's going to cost, how long it's going to take, and what your chances of success are, okay? So our specific topics will be why patenting software will likely be unsuccessful. Now, that's a little bit of, harsh statement. It depends upon the field your software is in. Some fields are relatively safe. Some fields, forget it. And other fields are a struggle, but it's possible. Okay? I'm going to give you a brief history of software patents and the history of patent trolls that led to the current situation. Okay, that because the history basically, drove us to where we are. If you understand what the abuses were, then it makes a little more sense why things are as bad as they are. And then there's signs of some future improvement. It's sort of like a pendulum that swung, and right now we're at the really difficult part of it. And there's some indication that we're starting to swing back to being a little bit easier. I'll mention some categories of software that are still patentable. So if you have something that's in one of those categories, you can be a little heartened. Maybe you're a little more likely to have some success. And then I'll explain some strategies for people with the money and the time who aren't in one of those easy categories. Explain a couple of alternatives to patenting. And then around midnight, we'll get to examples of successful and unsuccessful patenting. Okay? All right, so the primary step to get started is attempts to patent software products are likely to be unsuccessful. It's some exceptions. That should be your ground floor. It's hard to get a software patent unless I've got an angle, okay? Or unless I got a lot of money and time. Why is this? Well, there was a U.S. Supreme Court decision, SCOTUS, save space on the charts later on, back in 2014, has been used as a reason for two things. First of all, courts to invalidate many existing patents that had been issued earlier. So there was this golden age of patents when it was easy to get a software patent, relatively. Well, now those patents, as they're being asserted, are being invalidated left and right. Okay. The other thing is that the U.S. Patent and Trademark Office, which issues the patents, changed their examination processes and rules to adapt to Alice decision, and that's what it was called, Alice Corp versus CLS Bank. Now, in my opinion, it is actually harder to get a patent allowed than it is to keep a patent alive. So if you were to have a threshold for what does it take to get a patent allowed today, that's actually higher, in my opinion, this is just purely my opinion, than what it takes to keep a patent alive if it's already been issued. Okay. And there's some complex legal reasons for why that is. One of them includes a phrase called forum shopping, but that's beyond what I'm going to talk about today. Anyway, there have been several statistical studies by a lot of people because this is seriously impacting the software industry. Okay, the invalidation rates of patents that were granted prior to Alice and then used in lawsuits afterward, and patent application allowance rates after the PTO changed its rules to affect its interpretation of the Alice decision. I'll make a quick mention. I was hit by this one really, really hard. The PTO had had this pilot program where you could get accelerated examination if you complied with some special rules. And the rules were that you put in a glossary of patent terms. You know, what the claim terms actually mean, where you define them out like a glossary in a book. Because a lot of lawyers, they try to fudge the language, and they don't want to be pinned down on what the words mean, so they can pretend it means this today and something else tomorrow. So the glossary program was to take that wiggle room away from the attorneys. And if you complied with it, then you got accelerated examination. So I had this I worked on with my oldest daughter. It's going to be in the examples of unsuccessful patenting later on. You see where I'm going with this, right? And so I filed my application, and I got my first office action in 2 months. Now, how many of you have ever filed a patent application? How many years was it? 3? If it was a continuation, right? Probably a continuation. Oh. Okay. Yeah. Well, the why the picking it up early was an aberration. It's usually several years. I got my first office action in 2 months. It's the quickest I had ever heard of anybody. I've lost count of the number of patent applications I've looked at over the years. I'd never seen one that fast before. 2 months. But you know what happened in that intervening 1 month time frame? So intervening time. The PTO changed the rules. Alice had come out. I realized I had better move on this thing before the PTO changes the rules. I draft the application, send it in, the rules change. And I'm like, oh no. And a month later, I get my rejection. I call up the examiner and I said, well, thank you for the rapid, picking up application. And he said, well, I got to tell you, you gave me the best glossary I'd ever seen. That's why I went to you so quickly. And I said, yeah, but you did it with the bad rules. You would have done me a favor if you would have let it sit for a long time until the rules changed back. And he agreed with me and said, oh, well, sorry, I didn't think about that. Anyway, so the bad news is right now, if you're a startup company and you need a patent to prevent competition, the sad news is it's going to be difficult. But you're not the only one unhappy about it. There's a lot of people that are unhappy about it. And we're going to talk about that when we get to the signs of good news. All right, so there are 4 eras in the history of software patents. The early period, 1970 to 1990. Now, why wasn't there an era prior to 1970? How many of you were programmers prior to 1970? I mean, my dad did his PhD dissertation about the time I was born, and he had a 16K computer at his college, and it was all mechanical relays for the memory. There just simply wasn't a lot of software prior to 1970. All right, and then the State Street era. There was an explosive growth in software patents numbers then. Then the Bilski era, which was the first sign of bad news for patents, and then the Mayo and Ellis era, which RIP software patents. Google was 2004, wasn't it? What's that? So they were in the State Street era. Then maybe they were allowed. Maybe they were allowed in 2004, but they may have been filed earlier. Yeah, I'm pretty sure the pages, the ones I sent you, I'm pretty sure those were from the State Street era. Okay. So the early period patents were on basically computer-controlled processes. The computer would control some type of machinery. Okay. So one of the earliest ones I could find was granted in 71. It's a patent on a programmed computing means. Okay. And then the RSA algorithm. How many of you heard of the RSA algorithm? Right. It was used in PGP. Do you realize it was patented? Those guys, they wrote their academic paper and they patented it. That patent came out in 83. So it would have been expired by 1990. Yeah. And then in 1991, about 20% of granted patents involve software, according to the GAO. Now, how do you define software patents? I don't know. I mean, they have their definition. How you define things often changes the numbers. All right. Now, methods of doing business using a computer program, however, were largely viewed as unpatentable. A few did sneak through, okay? And that's what moved us into the State Street era. There was a patent granted in 1993, and this patent was on a complex method of reducing income taxes, sort of like the type of thing an accountant would do, a smart accountant. They basically patented smart accounting, okay? A little trick that rich people use or whatever to cut down their taxes. Well, the patent owner sued State Street Bank with it, okay? And State Street Bank's probably something like business method patents. They're not patentable. What's going on here? You should invalidate it. Well, it took several years, but the appeal case went up to the U.S. Court of Federal Appeals for the Federal Circuit, the CAFC. Now, the CAFC is just below Supreme Court. If you file a patent lawsuit, it goes into federal court, not state court. And then if you lose, you appeal to the CAFC, not your regional district court of appeals. Now, if you're all lawyers, you knew exactly what that meant. But in the meantime, you just hold on to it. And that way, if you're ever involved in a lawsuit, you know patent lawsuits are handled differently than, say, traffic accidents or labor lawsuits. Anyway, so Supreme Court, the Federal Circuit upheld the patent. They came out with a new rule. Basically, business methods are patentable if they produce a useful, concrete, and tangible result. So the number of software patents, after people saw this, like, oh my goodness, we've been holding back. Now you start flooding the PTO with applications, and very quickly the number of software patents shot up to 50% of the total that the PTO is granted. Okay, went from 1/5 to 1/2. All right. There's some consequences of that. We're going to get to that in a minute. So the next era started about 2008, where the CAFC gets another patent coming up, and they this time it wasn't actually an issued patent; it was an application. One of the examiners at the PTO was basically digging his heels in, not allowing the patent, saying, "Hey, this is a little bit too, squirrely. I'm not going to grant this." The applicant, of course, was probably arguing the State Street case. Oh, this is patentable. This Court of Federal Appeals said it was patentable, but the PTO refused to allow it. Sometimes, if you got enough money and the PTO doesn't allow your application, you can actually appeal to the that court, and that's what this patent owner did. And when it gets up to the court, they say, "Oh, guess what? We got it wrong back in 1998. 10 years ago, we got it wrong. So we need to change things." Okay. So they came up with, they tossed the useful, concrete, tangible result. It was a rush decision. I think you talk to most patent attorneys and they'll agree Bilski didn't do much except for say State Street era is over. But they didn't really give a lot of guidance. That's why the Bilski era is relatively short-lived, because there needed to be better guidance. But at least this cued people into the idea that the golden age software patents, it was starting to wane. Now note that State Street and Bilski were not SCOTUS decisions. They went to the appeals court right beneath. But the next ones went all the way up to the Supreme Court. So, Mayo and Alice. This is where we are now. Mayo was the first patent. Okay? It was a method of giving a drug. It was issued during the State Street era, during the early, easy years. Okay? And it was, it was an easy one to challenge. It was in the pharmaceutical industry, not in the software industry. Okay? And what the Supreme Court did was they created a two-phase test for what's called patent subject matter eligibility. Now, if you talk to a patent attorney, you might hear, three interchangeable words: Alice, 101, or patent subject matter eligibility. They all are basically different ways of saying the same thing. Is this the type of idea that you can get a patent on? Now, very clearly, if your patent is some new contraption or device that's got some extra levers on it that give it additional features that nobody else knew about, that's the type of thing that's patentable. But software, well, how much is software just automating something that people normally do anyway, right? So maybe that's not the type of thing that's patentable, because it's just something that somebody could do with a pen and paper. Well, the Mayo test, the issue was whether or not this method of giving a drug was just this type of thing that doctors would do in their office anyway. Like I've seen a patent, I'll give you an example patent, I can't remember the number, where somebody noticed that when a person had a first condition, they also had a second condition. Okay? Well, now there was a medical way to test for the first condition, but there was not a way to a blood test or anything for the second condition. But when somebody noticed there was a correlation, 100% correlation, every time somebody had the first one, they also had the second one. They had a patent on testing for the second condition by testing for the first one. Okay, how many of you think that type of thing should be patentable? Oh. Test for whether, the arm is broken by whether there's a bone sticking out through the skin. I mean, right. So anyway, this is a type of things that got allowed during State Street era. Well, the Supreme Court said for Mayo, no, we're going to have a two-phase test. And then, wasn't very long afterward, but a software patent comes up, and the Supreme Court said, well, we're not going to reinvent the wheel. We're just going to reuse the wheel. So they basically reused Mayo test and applied it to software patents. Okay, and that's where we are now. So, in my personal opinion, I got a real strong disclaimer here. This is absolutely not the opinion of any of the other members of the law firm where I'm working, any of my employers, or whatever. This is just me as an observer, being an inventor myself, trying to get patents for myself, trying to get patents for other people, litigating patents. This is just what the conclusion I've come to. Okay? Many software patents that were allowed during State Street era that covered way, way, way too much. They were just not the right things that should have been patented. And the other is the rise of patent trolls. Okay? Trolls, what they would do is they would exploit the overly broad patents that were allowed during the State Street era. Here's an example. This is a real example. We get sued by this patent, and it's obvious to anybody that we didn't do it. Okay? And we're sitting in a room with a guy that, owns the company that's suing us. Okay? And I sit down with him and I explain, we do not do what's covered by your patent because our phone operates this other way than, what your patent describes. Plus, look what we found. We found this other patent that predates yours, and if the patent examiner would have, seen this one, yours never would have been allowed. So we can get your patent invalidated. So not only do we not do it, but your patent shouldn't be valid. You think he said, darn, I never should have sued you. No. He said, cost you $3 million to do that. That, folks, is reality. Okay? That's why this court stepped in and said, no, we got to stomp down on this. Okay? So, many early software patents, yes. No, the company that I worked for at the time could afford that, but the point he was trying to make was what I call pay to go away. Somebody who has a loser case, but yet they don't get sanctioned. The patent reads on your product just barely well enough that the judge won't sanction them for frivolous filing. They just clear that hurdle. But there's like no way a jury would agree with them. Okay? Those patents fit the pay to go away model, which is it costs you so many millions of dollars to defend against it that they count on you paying them less than it would cost to defend yourself. The same type of people, same moral caliber, do both. Okay. It's being recorded, right? So there's going to be a lot of people that hate me. But that's just my personal opinion. That's why I had to differentiate. Okay. So many early software patents were simply too broad. Now, why is that? Well, the patent office decides patentability based on this idea of prior art. So basically, you send in your application and say, this is what I do. And then the patent office has someone that, named an examiner, called an examiner, and what they do is they try to search to see what prior art is, okay? And if they can find prior art to your patent, then too bad for you, you don't get it, okay? But if they can't, well, not yes doesn't mean no, okay? Sometimes it means they just haven't looked hard enough, right? But they're only allotted like a certain number of hours per application. They can't search everything, and you know where they predominantly search? Other patent literature. You know why? Because they know how to search it. And the dates of that are easily provable. So for example, let's say they come up with some thing they found on Wikipedia, right? And this Wikipedia thing shows the same thing, your idea. What are you going to say? You're going to say, wow, Wikipedia article was put up like last week. Okay, I filed my application and I've been waiting in the queue 3 years. So that's not before me, that's after me, right? So there's a lot of material they simply can't use. And that, by the way, is the subject of the presentation I'm going to be giving at Jerry's meetup. All right. Well, what happens if people hadn't been filing a lot of software patents before, and the patent examiners go search patents? All that prior art's not going to be there, not because it wasn't out in the market or companies weren't doing it, but because nobody filed patent applications on it before. Okay? And just think about it. How much software do you guys develop that you never patent? Right? I bet what you do patent is a fraction. Okay? So what does that mean? That means if somebody comes along and files a patent application on something that you did but you never patented, there's a good chance they might have got it under the State Street era. Not because it was new, but because the examiner wasn't going to find what you did. You didn't call up all the examiners at the PTO and say, hey, guess what I did? And all the other software developers do the same thing. No, it didn't happen. So the software examiners just simply couldn't find prior art on a lot of ideas. And then being argued by the attorneys, well, no prior art, you have to allow it. Guess what they did? They allowed a whole bunch of applications that probably shouldn't have been allowed. So this is what I'm getting at is most of you guys are developing software. I mean, after you get one project working, what's your number one goal? Getting the next one working, right? So you can get more money coming in. Patenting is something maybe your investors make you want to do, but it's not your priority usually. Okay? So anyway, all of this results in the fact that there isn't a lot of prior art on a lot of software, and so a lot of stuff got allowed that would not have been absent this phenomenon, relatively unique to the software world. Okay? And I have a interesting thing here. It's Information Week. Wow, I'm a dinosaur, huh? This is not that much, well, it's October 11th, 2004. So it's not back when I was doing the hex key programming of Z80s, but still pretty interesting. Made the cover of Information Week, the high cost of software patents. Now, this wasn't the high cost of getting a software patent. This article was about the high cost of existing patents on companies that are out there operating and they get sued by somebody. Oh, I didn't know you had a patent on that. And so that's what this is. And it mentions a Kodak case, and I actually worked a couple years later against the very same patent from the same patent owner, as is mentioned in this article, when I worked at BlackBerry. So Kodak was suing Sun. Yeah, Kodak was suing Sun, and that was this article. Later on, Kodak sued BlackBerry when I was there, and I worked on that case.
How many years ago they changed
So the rules to make it tough. Oh, and by the way, that article was the backdrop for why it became tougher. Okay, so by the time in 2008, when Bilski got up there to the federal appeals court, the judges there were already aware that people were yelling and screaming that there's too many easy patents have been allowed. So that was 2008 when it started getting bad, and then 2010 it was dropping off a cliff. Oh, sorry. 2008 was the federal appeals court for Bilski. Sorry, it was 2012 and 2014 for the Supreme Court.
Basically, had 3 years so there's about 15 years left
Yeah, and right now a lot of them are being invalidated left and right. Yeah, there's a lot of news coming.
Not here in this room, if they get that lost,
That is exactly that is a very good point Jerry's bringing up. So here's the situation. If you guys start a business and you start making money, and you get some negative attention, so you get attention from patent trolls, they could they could hit you up. Where did I get to? Yeah, I think that's the next one. Yeah, didn't take long for patent trolls to exploit the situation. Look these up, okay? This was a company here in the Dallas-Fort Worth area. It's a true story. It's 3 guys were working on a photo sharing system, okay? And what did they do? After 7 years, they'd saved up enough money that one of the guys was going to be able to quit his full-time job and work full-time on this company, which is what they really needed in order to get to the next level. Right before they did that, they get this letter from an attorney named Sam Baxter, not directly from him, somebody that worked for him, saying that you infringe on this particular patent. They looked up the patent. We don't infringe. So they try to talk to them and say, could you please explain to us how we infringe? And you know what the patent owner said? We do not need to give you patent infringement contentions until about a year into the case. Well, take a guess how much money these guys would have spent, right, before they got there. More than they had saved up. You see, in any patent patent assertion, there's 3 numbers. There's how much money the patent owner will take in order to go away and leave you alone, the pay to go away amount. Then there's how much money you can afford to spend on a diversionary thing, such as a lawsuit defense. It's not, developing your software, before you end up throwing in the towel and going bankrupt. Okay? Before you abandon the project. The third is how much money it's going to cost you to defend the lawsuit and get a jury verdict and an appeal of no infringement. Okay? Now, if it turns out that the money that would put you out of business is lower than the amount of money that it would cost you to defend, it doesn't matter that you don't infringe. Because they can drive you out of business. So, what do? If they're smart, they come take just a bit. Because if you throw in the towel and you go insolvent, then the lawsuit against you gets held up. Yes? I don't understand the question.
Of course you do.
Oh, they know. It's what the law permits. We're gonna get to open source in a little bit. I'll get to that in a minute. Yeah, the simple rule is that if the the way a lot of the patent owner attorneys would work it would be if they can file the suit and not get sanctioned, okay, then they'll do it. And if you don't infringe, that's not their problem. The law permits them to file. Now, in this case, the situation, the backdrop was this: these people, they wanted to go after Google and Apple, okay, but they didn't. They knew it was going to cost money. So what they did was filed against 160 some small entrepreneurs, mom and pop shops, 3-4 person outfits, okay, and collected in the tens of thousands of dollars from each of those to build up a war chest so that they could then go against Apple. Why? Because Apple would file Apple would fight them. Apple would try to take the patent away, and it costs money to defend a patent if the big guy tries fighting back, and so they needed money. So they got the money from these people, who ended up having to empty out their savings to pay off, and so their whole plan was derailed. Okay, this is the backdrop for why the law changed. Okay, it's not just because somebody in Washington, D.C. wanted to be mean and nasty and make your life difficult. It was because there were people who were exploiting the situation. You read these things and you get sick to your stomach. Okay? So there was a lot of pressure to fix the troll problem. However, it seems that the Alice has gone too far. Okay, I think that's a lot of the consensus, and it's because it leaves. I mean, there's legitimate people, like many of you, who need patents, but right now it's very difficult to get. Okay, so it's a bit of a knee-jerk reaction, I think. All right, now there are some appeals court cases since Alice that provide examples of patentable software. So these can be used as the basis for arguing with the PTO that your application is allowable, if your application is close enough. Now, what does this mean? So if you file a patent application and you get a rejection, there will be what's called claims in that application. So the specification describes what you do. The claims are the legal description of what you're protecting. Okay? You're not protecting the whole specification. You're just protecting a couple paragraphs at the end. Okay? Now, if you get a rejection, the proper thing to do, or the sensible thing to do, is to look at one of the cases that's already been up in front of the appeals court and has come back as a success. The appeals court said this is fine. And then what you do is you try to show why your claims are closer to that one and a case in which it wasn't so good. The patent validated. Buddy Ben here is good at that kind of thing. Anyway, so there have also been talk about legislative changes to create an eligibility standard that's more favorable to software. And there's some industry groups that are forming. So you can probably look online and see some industry groups and contact them if you have any questions, and you can see what they're pushing. The bad news is patent reform is just really not a high priority, given what's going on in Washington, D.C. now. The good news about it is, though, it seems to be a bipartisan effort. Dennis Leahy, Democrat, okay, and Bob Goodlatte from Virginia, ideological opposites, but they both largely agree on patent issues. So I tend to agree with those guys on issues. If you just happen to look in the news and see what they're talking about. Okay. Oh wait. Also mention some countries are a little bit ahead of us. India, for example, recently changed their rules because they're looking at what's going on here in the United States with Alice, and India has a large software industry over there, and they don't want the problems over there that we have over here, so they're kind of like cleaning up their own house. Yes? Not right now, because a lot of their market is export, right? And so patents are not extraterritorial. But I do give them credit for, I don't know if I would recommend filing. It might be good now to get in, but in my opinion, it looks like they are trying because they're monitoring what's happening over here, figuring out where the businesses that have been abused by trolls, but yet still favor there being patents on software. Okay, because there are companies that have been sued by trolls and are disgusted by trolls, but yet say this whole nearly blanket prohibition on software patents is too far. Okay, so they're trying to guess where we're going and beat us there. So patentable software. All right, so this is where hopefully you guys might see some of your own stuff, right? If you see some of your own stuff, you don't have to be so depressed because you might be able to sneak in on one of those. All right. Cryptography, including programs that use hash functions in a novel manner. Who can think of something that uses hash functions? So those patents on that seem to be, seem to be getting through. There's a lot of filing on it. So to the extent that people with blockchain inventions are worried about the general environment for software patents, it's not showing in reluctance to file applications because there's a lot of applications filed on it. Okay, modulation and coding algorithms for wireless communication, like Wi-Fi, cellular. So if you figured out a new way to squeeze a little more bandwidth into Wi-Fi, and even if it's just a software, such as, for example, the previous rules, we would use this coding scheme, this, for the data, but now we've measured the signal-to-noise ratio, and we have discovered that it's better to maybe break into two channels, each of which is lower, but there's some non-linearities in the way the modulation. This is the type of stuff I used to write patent applications on. So I don't know how it works. So things seem to be fairly safe. And then, of course, the stuff from the early days, computer-controlled devices, algorithms that have a physical effect. So, for example, if you've got a computer program that controls a drill for machining, of course, the drill bit, is going to wear through use. So maybe you've got an algorithm that calculates, or estimates how much wear there has been, and so alters the depth that it controls. Other things, toggling device functionality on and off. So if you have something, for example, I can't promise this, but if you have a cell phone and you've got some application and all it does is just show numbers on the screen, okay, well, no, that's probably not going to go. But if you have some physical effect on it, you turn a service off, maybe for some security reason or for some battery saving reason. Okay, if there's a physical effect, you've got a better shot. Okay, and then of course there's some others, but these are the ones that jump out as easy, relatively easy cases. All right, now some possible strategies. Okay, that absolutely has to be patented. FedEx should hire me to write slogans for them. Yeah, this is expensive. The meter's running, right, with a lawyer. That's why I became my own patent attorney, because I couldn't afford to hire anybody else. file an application now. All right, but you do this with your eyes open, okay? Why? Because it takes a couple years, right? Like one of the story I told you about the guy getting to me in 2 months, right? And I told him he didn't do me any favors because the rules are going to change back somewhat. They're going to be better down the road. And he agreed with me after I pointed it out. He never apologized for doing it so early, but if you don't have a special program, go ahead with detailed disclosure of the algorithm. Really? Yeah. So, how many of you guys written academic articles for IEEE? Okay, I've done that. Now you know what a big fear of a lot of academics. I've got my 3-4 grad students here. We publish this. There might be somebody at some other university. They got 6-7 grad students. Okay, they're looking for a research project, and they're going to overtake us. And guess what? They're going to be publishing. Maybe what I do is I leave out the secret sauce. And you don't put everything in that academic paper. You just put enough in there to get past the peer reviewers. But you don't put everything in there that people need to necessarily know to reproduce it quickly. Okay? Because you don't want other people doing it necessarily. Right? Well, unfortunately, it doesn't work with patents. Okay? Now, I'll tell you a conversation I've had with a lot of inventors. This is true. So, you're not telling me how this part works. Well, of course not, because if I put it in there, then everyone else can build it. I mean, that makes sense to some people, right? Unfortunately, for patents, it doesn't work. Why? Because maybe the examiner doesn't know you need it, and you might get allowed. But then you go to sue somebody with a patent. You know what the other side's going to say? It's not enabled. That's a legal word. It lacks enablement. And the bargain for a patent is you have to tell the world how to do something without undue experimentation. So those are the 2 key words or key phrases. Lack of enablement and without undue experimentation. That doesn't mean you have to give them all the source code, but you need to give them enough of the algorithm that a person of ordinary skill in the art, reading your patent disclosure, can sit down and independently recreate it. Okay? And if you hide stuff from them, that fails the enablement test. Okay? So you have to put in your secret sauce. There is something you figured out how to make it run twice as fast, and that's what your invention's on. Well, unfortunately, you got to tell everybody. And you know what this does? This actually plays into the question of, should you patent something? Because why? Let's suppose you're chasing a market, right? And you have something that is going to really skyrocket performance, okay? You have a choice. Keep it as a trade secret. You don't patent it. And you just hope customers flock to you because yours works better than your competitors, right? Or you file a patent application on it. You basically tell the world how to do it. It gets published on the PTO website. Your competitors read it. They go, that's their secret. So they start doing it too. Well, they're infringing your patent, right? Your patent hasn't been granted. That's still 4 years away. I mean, it's going to be a year and a half before they pick up the patent application. They're going to be fighting with the examiner for 2 years before it's allowed. And 4 years, who knows if you're still in business. But your competitor's using your ideas. Right? So maybe this detailed disclosure of the algorithm might be patents aren't for us. Now, I'm just committing suicide here as a patent attorney. But this is what I'm telling you. I was in a situation where I wish I was treated differently, and so when I became a patent attorney, I said, I will treat everybody like I wish I would have been treated back when I lost more than 25% of my pre-tax annual income. Okay? That was painful, by the way. single income household with children. Yeah. Yeah.
At what point does the status of the patent give it a patent?
So you can say patent pending after you file a provisional. Provisional's got a 12-month lifespan, okay? And then you have to convert to non-provisional. And then throughout non-provisional until either issued or abandonment. But once you abandon it, you can't say patent pending anymore. And once it gets issued, then you change from patent pending to patented.
There's a certain advantage to be able to say patent pending.
There is. It depends. Some investors will go, oh, you got a patent application done, so then you'll be ahead of somebody else, and some investors might require it. Yeah.
What point in time somebody else can see that?
18 months after you file, unless you request non-publication. But after it's granted, then, yeah.
Like for 4 years, if I file it today and my approval is at 4 years, somebody already sees it when that seeing is happening.
As early as 18 months, or if you're filing, or earlier, you can request early publication, and then it's a couple months. Or if you file a continuation, it'll be a couple months after filing. Yeah. How long can you delay it? You can request non-publication, and then up until the patent's allowed, then you can. Then it has to be published. Yes.
I work for Dr.
Yeah. The risk of not patenting.
It's all trade people, right?
Yep.
Nothing that so that's all those formulas.
Yeah, it's a dice roll. I actually have. I was going to mention this earlier. I guess I forgot to. I actually have several books, small little booklets I've written on how companies use patenting, and the question of should I patent or should I not patent? If I have a patent, what do I do? I actually go into that those topics in these. They're also, I believe Tony put them on the Dropbox. These are just paper copies in case somebody is a dinosaur like me. Yes. Non-disclosures give you a right to sue the person who signed it. But if somebody independently develops something, a non-disclosure isn't going to help you. Oh, non-publication? Oh, if you do, you could do a non-publication and delay, but you can't file in another country. Let's say you want to file overseas. You can't file. Yeah. Right. The other thing is this. All of these questions, they're basically risk tolerance and your own situation. But if you choose non-publication and your competitors files shortly after you, okay, your application cannot be used to reject their patent application, okay? And so one of my articles has this little flow chart of what you do with an idea. And one of them is, let's say you're not going to patent it. Maybe what you want to do is you want to publish it out so people can see it, because one of your competitors might get a patent on it. So let's say, for example, you file the first month and the competitor's files a month after, okay? And let's say their attorney is just a little bit faster at responding to PTO actions than yours is, okay? Their patent might issue before yours does, okay? Now, when yours does, it has a priority date earlier than theirs. And so if the two of you get into a lawsuit after you've both spent $5 million, maybe you'll get away for $2.9 million, okay? Do you have an extra $2.9 million? Because if you do, I'd really like to be your friend. Okay. Well, then, after you spent your $2.9 million, okay, then their patent goes away. But before that, they're telling you the same thing that guy told me, which is, well, yeah, you can invalidate my patent, but it's going to cost you money, so I'll take a little bit less and go away. Okay, but if your application publishes, then before theirs is allowed, then your application can be used as a rejection basis for theirs. Okay, so there is value in publishing things. Yes. I'm sorry, I didn't quite understand the question. Right. Yeah. Any other things? Oh, okay. Well, it used to be half would be software patents, but now it's probably lower. People are still trying. Okay, people are still doing. Other people are doing this process. Whoops. Other people are doing this process right now. Okay, there's people doing this, and there's a lot of people doing this. It's just expensive, and I'm just telling you, if you go ahead and do this, if you got the money, you got the time, just be aware there's potential cost and money delays. Yeah.
That's his other advice. From a patent lawyer from the control firm, you don't have to bear any costs of legal defense.
Yeah. Oh, listen. I have this. I should have brought it with me. I had this flyer called. It's advertising patent prosecutors. Live under a rock and associates. Yeah, and the advertisement is: do you have an obvious idea that's older than dirt? We can get you a genuine U.S. Patent application pending for as long as you can afford to pay our fees. Okay, so I have throughout my career always told people, listen, if I was in your situation, I wouldn't spend my money on it. Okay, if I thought that was a situation. So I'm honest with people about that. But at the end of my advertisement, I have a little asterisk that says, nobody makes money off of patents except for the attorneys. Right? And that was a cynical thing I came to the conclusion of after I had to tell my wife I'd wasted the money. She said, we lost all that money? And I said, yeah, but the patent attorney made some. I don't want to disparage the profession.
But let's say you got three people in here who are similar to the people who photo.
Ouch.
Well, but they're at that stage where they're thinking, getting together. Maybe you're going to get this later, so but once you give the people here some advice as to how do they check out their risk.
Oh, I don't have anything on litigation tactics. Sorry.
Are there services beyond going to expensive patent lawyers like yourself where you can do a bit of analysis and say, hey, like the patents that are similar to what we're doing or X, Y, and Z, whatever individual analysis are they not?
I've seen things spring up like that, but I don't know how effective they are.
But as far as you know, all you do is go talk to a patent lawyer and then go through that.
Yeah. Sometimes your biggest enemy is your own attorney's bill.
So are you saying that your advice, just do it, and it's not worth even trying to check and manage your risk?
Unfortunately, sometimes damn the torpedoes, full speed ahead is is your option, and you just try to stay out of their sites.
Well,
Okay.
anybody, this is for everybody. Anybody can do a patent search. Whether it's USPTO.gov, if you want to try and you don't want to pay Cal, you want to pay.
No, I do want to be paid. You all send. I will file any application any of you want.
You can try to do, and actually that's a discussion. You can try to do a patent search to see if there's some risk effects to what you're doing out there, but your problem is number one, as a patent lawyer, so your sense of analysis will not be great. Number two, as Cal has told me in the past, by the way, I'm not a competitor, I'm a corporate security. Cal has told me in the past, you're unlikely to come up with all the search words that will reveal all the facts. If they're out there, that you can find if you need to worry about a patent troll coming after you for it. So I guess Kelsey advice is get on that treadmill and run.
Yeah.
It'll knock you off.
Right.
You guys can't do it today. They get 5 years in, they're really starting to get traction. The patent that's going to be on could be 2 years old.
Yep.
No,
Exactly right.
That was the new
Yeah.
rules, right? Because basically.
Well, yeah, not with the new rules, but yeah,
You've got 15 years approximately of risk. Right? The rules change such that patents that, from a software perspective, that might be problematic for you would be at least about 5 years old.
Yeah.
And there's only a 20-year patent.
Yeah. So just wait 10 years. Okay. All right. Yeah. And then do your app then, right?
Yeah. So
for the same
5
song.
years in, so
Yeah.
maybe the patent. Every year goes by, some of those patents are going to be.
If you all want down the road, like after the other ones, the nightmare scenario on the trolls, I do that. I'm trouble, but I can do it. All right. So then let's say you go ahead and you file your application. You're going to go forward, and because I haven't talked you out of it, and you don't rush the examination process. So when the PTO sends a letter, you typically have 3 months, and then you have to start paying fees. And then after 6 months, then basically they kick you out of the queue and tell you, too bad. Well, take the 3 months, okay? Maybe take a 4th month if you have to. And you hope that the rules will change to be more friendly to you. By the time the examiner picks up your application. But if they don't, you just expect the fact that you're going to get that 101 rejection, 3 phrases, 101, Alice, patentable subject matter. All 3, you're going to say 1 or all 3 of those. Okay? And then you file an appeal. So the patent application I told you about that was unsuccessful, that's what I did with it. I mean, I filed it, and then the rules changed, and I got hit, but then I took my time, and then I filed a tab appeal. 2 years. So your grandkids be picking up your patent application with hopefully different laws. In the meantime, all of your competitors have made money on your idea too, and you didn't have a patent to shut them down with. And that's just a sad reality of the situation. This is why there's so much effort to change the laws. But laws are going to change better for the better, I believe. All right, so alternatives to patenting, and we're going to get to this open source thing. So copyright, one of the things you can do is you can copyright your source code. Now, of course, everything is automatically copyrighted, but you can register it with the Copyright Office if you want. Okay, it doesn't always work well. Oracle sued Google. That was a hugely watched case because what Oracle did was they copyrighted their APIs, and Google was hitting them with, their Android operating system, and so Oracle sued Google for copyright infringement, and judge ruled that it was fair use. The other thing is you can protect intellectual property's trade secrets, which is, what you do with the soda industry. You just hope people don't figure it out. Yes. Yeah. Bought from Sun. Yeah. So, Oracle got it from buying out Sun. Google?
And my understanding is that they stripped all the comments and license and just use the code.
No, it was the issue over the APIs. The Google, Google's using the APIs, and so Oracle said they copyrighted the APIs. So, too bad.
They wrote fresh code.
I believe it was their own code. Yeah. Anyway, but Oracle wanted in on some of the Android money, but they didn't get it. They sued them for like it was billions of dollars or something like that. I had a friend that worked on the case on the Oracle side. Anyway, the other thing is to protect the intellectual property's trade secrets. You can use technical protection measures such as anti-tamper, anti-reverse engineering, and secure development environments. Now, as I mentioned, I have a bunch of these articles that I've written about how businesses use patents, and those are generic. They're not, software patents, just general patents. But if anybody comes up to me afterwards and they give me a really good question or comment or something that really sticks out, I'll give you this. This is my Crown Jewel Door Prize. It's an article I wrote. I made the cover of this magazine on software protection measures. So basically, I was a hacker for the government for a few years. I'd hack into our own stuff to look for vulnerabilities so they could be fixed.
That's your second security mission.
Did you? Me specifically? Yes.
We're shutting down the building at 8 o'clock.
At 8 o'clock?
Yeah, that's, your session was supposed to end at 8 o'clock.
No, yeah, we've never been asked to before, but.
Well,
That was
tonight
the
they're
rule.
shutting down the building.
Okay, all righty.
Right then, I guess I'm not going to get to NDAs. I guess we'll have to pack up our stuff.
And nothing tells us advertisers are not engaged.
All right, you'll have to get the stuff off of the website. Here's the ones these are all mine, so I can put them up. I got permission from the owner. What's that? Yeah. You can find me at Grable Martin Fulton website. I do patents and privacy and security, and that was my final thought for you all. We'll have you.
He's in so much, I feel I should say he's among the most inventive intellectual property lawyers. Not just patent, but the kind of patent lawyer likes to work with.
Last chance to put in a business card. Thank you very much, Gus. So we're going to have a little raffle. So tell us if you could do us the honors. People put in different cards. And then we're going to have a little gift for the speaker. So hang around. Okay, here we go, folks.
A white one and a black one. Go ahead and grab them both. All right. Mark Eichener.
Okay, and Kelts, could you take a picture of us? Kels, I have something for you. This is appreciation for here. Okay. Take about 5 of them. Just come out.
Make me look like Brad Pitt. Take off 20 pounds from here.
Okay, I'll make it.
Thank you.
Not always.
So anybody, who's the winner?
I'll let you keep my card too. Thank you very much. I appreciate it.
Thank you for coming.
Thanks for the event.
Good job. And here's this gift for you.
Thanks for having me out. Appreciate it.
Absolutely.
So I think it's the same. We go to Meetup.
Thanks, Tony.
Sure, Susan. Thanks so much. It's going to be a trick to see you. I'll do it. I'm good.